And we are live. Good afternoon, good morning, wherever you are. I've really missed you, all four of you. I hope everybody's doing well. No jokes today, zero jokes. Because we're sponsored today by, as my shirt says, Santa Monica Brew Works. We're actually not sponsored by them, but a friend of mine owns it. So if you're ever in, and he didn't ask me to say this, nor is he going to know I'm saying this, but if you're ever in Santa Monica and you're looking to have a beer and like a beer garden, look up Santa Monica Brew Works because it's well, I guess a lot of people go there and it's an enjoyable place. And say hello to Scott and tell him Rick sent you. There you go. So wasn't planning exactly on doing a live or a video today, but I decided to. I was going to do it yesterday, but I ran out of time. Today was a hearing in GTII, and because of part of the content of the hearing, I thought it would be essential that everybody be brought to speed up to something that seems to be a real problem. So I will, and I'm kind of going to talk slow for a little bit so some additional people can join in that might be interested in this, because I'm sure everybody will be interested in this because this has been an issue that's been discussed quite numerous times. And so as I'm babbling and I'm kind of wasting the time I usually would tell these bad jokes, but this is a different bad joke. So let's hear it. So today, the hearing occurred in Las Vegas. Last one I attended in person. I haven't decided about the next one. Um, this one I attended via Zoom, and I've attended all, as far as I know, I've attended all the court hearings. I think there were some shareholders because I got a text from Renee afterwards. I think there were some shareholders that also either watched the hearing or participated. The nature of the hearing today was designed to, it was a status update. That was one aspect. And then there were two other matters. One, and I'll kind of discuss those two matters, and then we'll talk about the bigger issue as kind of people, or if people roll in. So number one, the hearing was um, to affirm a settlement between the receiver and Luke Rabari. If you recall, Luke Rabari was the guy who came in kind of after the fact to clean up the company. And then when the receivership came in, he was no longer with the company. And the basic dispute, I guess that this is based upon what was discussed in court today. And in court today, the receiver was not in court personally, but was apparently there via Zoom. Attorney for the receiver was there, and Luke Rabari's, I think, I don't know where the counsel was from. I believe it was local counsel in Las Vegas. He was there, and the issue was they had worked out a settlement, and he had previously received 8 million shares. They worked out a deal where he had to give back, 8.6 million shares. I think I said 8.8 million shares. They worked out a deal where he had to give back 6.6 million, so about 70%. I think it's about 70%. And basically, the premise was he had performed services, so the receiver thought he was entitled to some portion of the shares. He got involved long after all the basic shenanigans by Reichman had occurred. So the receiver thought he was entitled to some compensation, just not the entire compensation. And so that was the deal. The judge approved it. I'm not going to make a big deal out of it. It was a reasonable compromise in legal parlance. You're certainly not going to litigate it or try it. So is that a fair and reasonable settlement? Probably. It's in the ballpark. I'm not going to bitch about it. Second, or I'll bitch about it, but it's not going to change anything, and and the judge was going to approve it anyway. It was reasonable enough to be approved. That would be the bottom line, whether it's good or bad. Second point was there was a stipulation entered into between Reichman's counsel and the receiver where money that is frozen in Reichman's account was released, a small amount, relatively small amount, $11,000. What was that money to be used for? In court, it was, and I think it's referenced in papers, but in court it was referenced that it was used or needed to do an appraisal, and this has, without, they weren't clear about it, but this is the way I read it. So there's negotiations going on between Reichman and the receiver about Reichman giving back at least most of his shares and perhaps other assets. What other assets could that be? One of those other assets is the property that he acquired in Westwood, the condo or whatever. He doesn't have access to any money right now. Not that we're like throwing tears or anything, but he doesn't have access to any money, even if it's from his accounts, because all his accounts were frozen by the receiver and the court. So there was one other or two other occasions where he got a small amount, and it was all correlated in some fashion to GTII. That was the reference. And this one also. So apparently he was able to get $11,000 of his own money out of his own accounts. It was represented as not GTII money, although I don't really know, because if he took GTII money, I don't know, whatever. But that will relate to point three in a way. But they let it release. And again, it's supposed to be to get an appraisal. And I can only presume that the appraisal is going to be used either to pull money out to give to the receiver, or with regard to a transaction, or valuing something in addition to the return of the shares. Now, do I like the fact that Reichman has access to any of those monies? No, I do not. And I hope that he is not personally benefited outside of that. But if it was his money and they had made a motion to the court as opposed to stipulating, there would be a cost of objecting to that. And if he could show that was for the benefit of GTI anyway, the court would probably let him get his own money anyway. So notwithstanding the fact I would object to it just on principle grounds, the fact that they made an agreement, he got $11,000 and an appraisal is being done, I guess, within the next 2 weeks, and that relates to GTII and that relates to a possible settlement. So that sounds positive. Sounds like perhaps some additional capital might be coming into GTII, and it sounds like the shares of GTII will be returned. So those are the two issues that are kind of like whatever. Now let's move on to the real issue. So number 3 is a status part. And as you recall, I mean, if you've been following me in any of my videos, any of my tweets, I've been bitching about the audit. And I bitched about the audit with respect to, we had the guys, and I'm just going to recap it. And I filed 2 declarations with the court. The last one, I think in March. I think I filed one in February, January. But I've been bitching to the Receivers Council before that. I've done videos where I bitched about it for various reasons. And just to recap it, auditors, Borgers, that's of GTII's prior management. Borgers is terrible, so the SEC basically shuts them down. They have to do a re-audit, and it was a lot of companies that impacted, because Borgers was a whore, in my opinion. And so they would take anybody's business and apparently, the way it looked like, they just make up numbers. They would use past numbers, and they just were generating large capital for their own pockets. So they were kicked out. Then another entity was chosen by prior management. I think it was Fortune CPA. No action was taken by the receiver against Fortune, despite the fact that after 3 or 4 months, they had to fire Fortune because they weren't doing the job. And I think I bitched about that time. Why would you stay with, if you claim that the prior management are fraudulent scumbags, why would you stay with an auditor that they chose, especially considering that the prior auditor had been shut down and that Reichman himself was a tax guy and all this stuff? So it wasn't like likely that prior management didn't know what was going on. It was more likely they did. So with that in case, why would you choose the same auditor that and by the way, I bitched about this at the time. I bitched about this in my pleadings with the court, and I'm bitching about it today. So this is like a consistent pattern. You could look back if you want. So just so you understand that I'm not just saying that today. So they wasted time dealing with the second auditor that Reichman and whoever else had chosen. After a few months, I think it was like 3 or 4 months, uh, the receiver fired Fortune because they weren't they weren't operating, they weren't communicating, they weren't doing their job. So if you recall after that, then the receiver or the receiver's counsel, I don't remember which one, I'm going to have to look back at the reports, had a personal relationship or had used another auditing firm, and they chose that auditing firm. And if you recall, or just to remind you, they selected an auditor, and that auditor was either pregnant at the time they selected her or got pregnant and couldn't complete the job for whatever reason. So they didn't suggest going out to another auditing firm, and I don't know why they wouldn't know or why the auditor wouldn't tell them, or whether they mis misappraised how long it would take, or somebody was not being truthful to the receiver. I don't know. But clearly, they didn't know that the person they hired after the two prior failures also could not complete the job. So after they bailed, they brought in two additional people. And these two additional people apparently, and it doesn't make any sense to me why they would have to, but they started over again. And they've been and during this time in the reports, because if you've been following, we talked about all the reports that were put out. There were various representations, and I'm sure they were all hopeful about the audits coming, the audits coming, the audits coming, various conditions, and those conditions would be satisfied. Like at one point in time, there had to be a sign off on all the attorneys, and it suggested that something immediate was coming out. So there's been multiple, and again, I'm going to go through this because it's going to have to be presented to the court. But there were multiple times where they gave indications that the audit was going to be complete in a near time. So I can only presume that the person that was providing that information to the receiver was either not being truthful, or was not being accurate, or was intentionally being inaccurate, because it happened multiple times. And I can't believe that there would be an inadvertency, that the auditor would inadvertently make a mistake 9 times. And I would also to me, if I was an auditor in this case, after Borgers got skewered by the SEC and put out of business, after Fortune got fired, I mean, I would think I'd want all my ducks in a row. And I would also think the flip side, that the receiver would be super sensitive to this issue in light of the prior incidences with the prior auditors and with the claimed misconduct that the receiver has asserted against prior management. I would think that they would be super on top of it. So we got Borgers, then we got staying with another bad, apparently, another auditor that couldn't do the work, then selecting an auditor that couldn't finish the job, and then they added 2 more auditors that apparently had to start over. And this all sounded like nonsense to me, by the way, at all times, and I raised it as such. And over the last few hearings in court, it's come up more so that, or at least the receiver has been pressed about, the status of the audit. I think the last time I even referenced the receiver volunteered. Well, the receiver said, I think the last time, and it's not the first time. He indicated that, he expected that audit any moment, but he didn't know when. He couldn't say tomorrow, but at this point in time, he's expecting it at any moment. And the judge asked him, this was the last hearing. And, but he did reference there was 1,000 transactions that were, oddball transactions that he wanted the judge to look at, but the judge elected not to look at it based upon, I think, the representation that the audit was going to be done any moment. So we get to today, and it seemed to me very vague But so after discussing the first couple of matters that I referenced, then Dylan Siciliano, the attorney for the receiver, and I'm not accusing him of any not doing anything wrong, of not accusing him of being involved with the audit. Just so we're clear, he's just a counsel for the receiver. The receiver is responsible for the audit and for what's the contents of the receiver's reports. But the receiver's counsel starts to talk to the court and basically says that they've had recent conversations. I don't know, it was last night. I gather it was last night. Had recent conversations with the auditor, and they expressed concerns about certain transactions, and they had to add a third person, and then they wanted to switch to hourly. And so they wanted to change the compensation, the way the compensation was done. Now, again, this same firm originally said they would complete, and this is the third firm. This same firm originally said by the female partner, I guess, that she would complete it. She didn't. The next two, and I don't know who they are, came in and said they had to restart the process. And I don't know why. It makes no sense why they would have to restart the process within the same firm. And I've raised this before. It makes no sense, and it makes less sense today based upon when it went on. So there's communication apparently between counsel or the receiver and these auditors, and they're basically trying to change the terms, and they need more help. But clearly they're not done beyond that. And today, apparently 35 minutes before the hearing, they sent a letter to, I couldn't tell if it was to the receiver or the receiver's counsel, resigning. So the auditor has resigned. Now, I don't know if they will unresign, but it sounds like that they're trying to, you can use whatever word you want, extort, squeeze, manipulate the receiver. If what the receiver's counsel said was true and now they're trying to renegotiate and they haven't completed the job, that sounds like they're trying to extort, squeeze, manipulate, some word. I don't know what the word is, but it's not, doesn't sound like a fair deal. And the fact they haven't completed the transaction, and it doesn't sound like they're close to completing the transaction, really calls into questions all of the representations that are made in those reports. So as a result, and the judge was quite surprised, that was my impression, the court set a hearing on May 6th where both the receiver, and the receiver didn't appear today, and I don't know if the receiver didn't appear because he didn't want to be there and take the crap for the mishandling, apparent mishandling. Well, I certainly haven't completed the job of the audit, and it certainly appears to be in complete disarray. So I'm going to say mishandled because that's the way it looks. But he wasn't there today, and I don't know if he expected to get berated or something, and he thought it was easier if he didn't appear. Perhaps, I don't know. I don't know if he even knew about this. Maybe he didn't even know about the letter. I don't know. But he's ultimately responsible for the audit. So when that really pissed me off, and it pissed me off in part, and I'm going to quote an email I sent so you could kind of follow this up to date. So, I peered on it, I heard that, and I was annoyed, to say the least, for like 1,000 reasons. And I reached out to the attorney, Mr. Siciliano, and at 9:26 a.m. this morning, and I said, I was bitching about the auditor for months, and you poo-pooed it even in court. I'm furious. Have a good day. So, and just to relate that, and I think it was the last hearing or the one before last, he completely tried to rip me for questioning the legitimacy of the current firm. I had asked months ago for a representative of the current firm to appear and advise us of the status. Obviously, like like I was when we started this stupid maneuver, my instincts were correct. I smelled something, and today confirmed that. So I did not appreciate receivers counsel poo-pooing my correct analysis. And obviously they were not skeptical enough and not critical enough and weren't diligent enough in following up with the auditors and weren't suspicious enough. And there was clearly enough information there for them to be on notice. And that's not just the receiver, that's the receiver's counsel. And that pissed me off. And when he called me out in court, I would not be quite as worked up if he hadn't called me out in court and questioned my analysis. So I basically tell him, I'm pissed. I'm pissed, and I think you guys fucked up, is what I'm telling him. And he responded, I appreciate that. You and every shareholder and me, alderman, I don't know what he means by that, have an interest in finding out what the fuck happened. That's his response. So we have a hearing on May 6th. I urge you all to go back and review all the receivers' reports and see the references to the status of the audit. And if you have, if you after that, if you want to communicate that to the receiver, feel free. If you want to help him complete the process, feel free. But I think there's something clearly, there's something rotten here. I don't think it necessarily has to be on, and I'm not accusing the receiver or counsel of anything. I'm only accusing them of not being diligent enough and not being skeptical enough of obviously a pattern related to the audit that should have put them on notice to take action much earlier than now. It's not like something that's been hidden or that they shouldn't have known. They should have known, or at least they should have been more diligent. So there's a hearing on May 6th. I intend to participate in that hearing. Those who are represented either by counsel for, there's a plaintiff's group, Alex Calloway. If you're in the plaintiff's group, contact those people and push them to participate and protect your interests and to grill both the receiver and, more importantly, the auditor to find out what, as Mr. Siciliano said, what the fuck happened. And if you're with other counsel, and I'm not going to speak to other counsel because they participated today, I'm sure they will have their own view of things to say. But listen, participate, and this again an issue that's been this singular issue since September of 2024. We've been waiting for the conclusion of the audit. It's just not reasonable. And the actions, as cited by Mr. Siciliano today, of the auditor and their departure just out of the blue without completing the transaction after having delayed it and having apparently misrepresented their availability. And I don't know how much money they've been paid, but I don't like it when someone extorts you for their services. And that's what it sounds like for me, and my definition of extorting you is like if you have a job, you're completing a job for somebody, could be any business, and you're not done, and you have an agreement to do it at X price, and that person comes to you and says, I'm not going to complete the job unless you give me X plus $500. That to me is just not right. And that's what sounds like the auditors are doing here, at least according to Mr. Siciliano. And I don't even know who the auditors are, by the way. I don't even know their names or whatever. So we're just talking generally, and I've never spoken to them, so I don't know anything about that. But one, we have a problem again with the auditors. And two, I think the receiver has really, in my opinion, has blown it when it comes to the audit portion. And he's got a lot of explaining to do. And again, it's not something that they shouldn't have been aware of. especially considering the history of the audit. So make your voices known if you want. Do what you want. I'm not telling you what to do. Um, but if you want to, let people know. If you have counsel, let your counsel know. You could let the receiver know. You could let the receiver's counsel know. But when you do it in a civil way, um, because the judge certainly reacts when things are not done in a civil manner. And Mr. Siciliano seems to focus his attention on those kind of things. So if you have any communication with anybody, please do it. And this applies to any dispute. Please do it in a civil way. You can make your point, but please do it in a civil way. Don't cuss at anybody. Don't accuse anybody of it, of anything. But you're entitled to assert your opinion and do whatever. So next hearing is May 6th. I presume that we will have a lot of information by May 6th, if not sooner. And I think it's just like inexcusable that the audit is in this position. And whoever managed that process, I think, has done an abysmal job of managing that process. So we will find out on May 6th what occurs, and we will see from there. And again, I just want to make clear that I'm not accusing. This is not me accusing the receiver or counsel of doing anything. I have no reason to suspect they're involved in any aspect of the actual audit. I think it clearly, as Mr. Siciliano said today, he's hearing from the auditor, and this is kind of like the last thing. Correct. So I have two problems. One, I have a problem with the auditor. Two, I have with a problem with the receiver, is the oversight of the auditor and kind of the Pollyannish view in light of everything that occurred prior, in light of all the delays, just kind of accepting everything at face value. I just don't vouch. It just bothers me. And I'll throw this out as the last point. So you hire this auditor to do a audit of multiple years, and they find on all these questionable transactions, and you've had two prior auditors. You had one that got kicked out of business, two that you had to fire. You actually had a third one who didn't complete it. Then you had a new auditor who had started all over, and now they're trying to get more money out of you. So is this an auditor who was represented by either the receiver or the receiver's counsel as being legit and somebody they had done business with? Is this an auditor whom you can rely upon? The fact that they're trying to squeeze us for money, is that somebody now whose content I can trust, who hasn't finished the product? This is not a case where, as far as I know, this is not a case where the job is done, and let's say you got your car done at the garage. It's complete, it's ready to go. You owe them $953, but you haven't paid them, and they're not gonna release the car until you pay them. And it actually turned out there was an extra $150 on top of that, and you got to pay that, or else you can't get your car out. That's one scenario where the job is done, and that they're not going to impact the completion of the job in a positive or negative way. And you have another one where they haven't even started the job and they're raising the price. And so here, I think we're much closer to that. So can we really trust the results of an auditor who seems to have pulled a fast one at the end? And can we trust the judgment of the receiver in selecting the next auditor? Because it seems like so far they're 0 for 2. That's the way it seems like to me. And that's not a good ratio. Even in baseball, that's not a good ratio. So I expect that we will hear a lot more information in the near term. Obviously, I will be participating in the hearing on May 6th. I will keep you apprised, and we'll see what happens. I wait to see the status of the audit, what goes on, what the judge's position is, what the receiver's position is, what the excuses are, and where we go from here. The Receivers Council did suggest getting a new auditor, so I think ultimately that will happen. But that's a delay. That's a delay, another delay thing, because theoretically somebody would have to start over, and that just doesn't sound right. Just doesn't really sound right. So anyway, so that's up to date as of today, based on this morning's hearing, and now you have all the news that's fit to print. I know it's super annoying. I can tell you I am super annoyed and pissed. Yes, I am. But we just have to deal with what we got. And I know there's stuff going on in the background otherwise, separate and apart from the audit. So we'll have to see how, if anything else pops up. But this thing with the audit really pisses me off, and it should piss you all off too. If it doesn't, then so be it. But if it does, let your opinions be known nicely, in a nice fashion. And if you're represented by counsel, let them know. If you have an opinion, let your counsel know. Anyway, I can keep on repeating the same thing over and over, but that's the sum and substance of it for today. Everybody be well, take care. I will keep you apprised. Obviously, I'm following this, even if you don't hear from me at a couple of weeks at a time, whatever. I'm following it. I'm still attending the hearings. I'm still on top of it. So you can rest assured that when something material happens, like today, that you will know as quickly as I can communicate that to you. So everybody, take care, be well, have a great day. I'm sure we will have a lot of information coming up, and maybe, maybe this will somehow cause the audit to be finally completed. I'm hopeful. I don't really trustful, but I'm hopeful. Anyway, everybody be well, take care, have a great day, and see you soon.